ले लीजिए, अभी कैरेक्टर एविडेंस के ऊपर आ जाएंगे हम लोग। Today we had to start from character evidence, isn't it? Yeah. Hmm. Yeah. So this is the ये पार्ट 1 का लास्ट चैप्टर है, that is character when relevant, that is starting from section 51, grounds of opinion when relevant हो गया, अभी character when relevant, so relevancy and the so we learned from section 5 you have to lead, the law code permits you evidence to be led with regard to which are in fact in issue under section 5. Then 5 tells you also permitted to lead evidence relating to relevant fact. Relevant facts are covered from section 6 to section 55. So we have so far covered 55. That is a opinion of the experts, isn't it? Now the last semi chapter, that is 52 onward, देख लीजिए. Character when relevant in civil cases and criminal cases में दोनों distinguish कर लेंगे इसके अंदर. या देख लेंगे हम. Now open the section 52 onwards. Yeah, in civil cases, character to prove conduct imputed. Imputed mean the conduct which the court relies upon, or the conduct which is normally inferred, where inference is drawn upon, is irrelevant. So in civil cases normally are irrelevant unless the character itself is an issue. Let us see that. In civil cases, the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him is irrelevant. Generally, conduct agar issue nahi irrelevant, except in so far as character appears from facts otherwise relevant. So what are the types of cases I'll give you where character can come into play? In civil cases, in matters, normally in plain matters, when you file a suit for a summary suit, I have executed a promissory note in your favor, I have not paid the money. It's a breach of promise, or it's a commercial transaction where upon the bounce of check, upon the non-fulfillment of a contract, you can pay the money, satisfy. उसमें कैरेक्टर के बारे में बोलने की जरूरत नहीं. He is a dishonest man, he is so and so, जरूरत ही नहीं पड़ेगी. And that itself is not. In a suit for declaration, that when you go for a declaration that you are entitled to particular property, or you are entitled to ownership of a property, उसमें character normally is not involved. But you are proving your right title interest on the basis of your documents. Whether you are claiming ownership rights on the basis of your title, or whether you are claiming a right on the basis of your tenancy rights or subtenancy right, easementary rights, तो उसके अंदर कैरेक्टर को इंप्यूट करना जरूरी नहीं. But character comes into play in civil cases when yes, it does come into play in certain cases. In a suit for defamation or libel, defamation to of course a criminal case हो जाता है 499 में. At the same time, you can file a civil suit for claiming compensation on the ground that you have indulged in a campaign of vilification, as a result whereof I have been defamed. You are entitled to damages. So उसके अंदर you can take up the plea that the accused person, the defendant, is generally of a bad temper. He is a man who doesn't know to behave in society by making allegations. Wild allegations, he has destroyed my reputation. He is untrustworthy person. So his character is below par. ये सब चीजें are imputed in cases normally. What you call it, the defamation cases are libel cases, very good. And similarly, in custody matters, matrimonial matters, in a custody matters, husband and wives are bitterly fighting together. Fighting together. There are judgments of the various court which say that here the paramount factor for consideration in a prayer for custody or visitation rights of a child is the welfare of a child. Now, welfare of a child की जगह माँ बाप गाली गलौज देना शुरू कर देते हैं. The husband will allege the woman is not fit to be the guardian because she has so many affairs with so many people. Wife will say that no, he is not competent to be the guardian because he has neglected the family. He is generally of immoral character. He is visiting prostitutes, and the child will have a bad experience, bad influence. So ये सब चीजें करने के बाद, so character of a husband and wife will be an issue here. The court will consider whether I should give visitation right to the wife or to the wife, considering who is having what content. So normally character is not relevant here, but character becomes relevant here. See, isn't it? Oh, the husband and wife are fighting like dogs and like people here and attributing allegation. Uske andar the court will see. And secondly, in the matter of say two partners or maybe there's a case which went college management, whether who should be the head of the department and who should not be the head of the department. Uh, Such matters also come to the court for a declaration that the promotion, demotion is illegal and grant me damages for having demoted, and B has done it. If during the course of the trial it comes to the knowledge of the court that one of the defendant or plaintiff has made certain entries, it comes to the court, though a civil suit for declaration or maybe promotion, the court can draw inference that here the character of the defendant, which otherwise is not relevant, become relevant. Because the defendant has committed forgery, there's a falsification of account. Now, for claiming for claiming for claiming relief in the court of law, he has forged some signatures. हाँ? तो उनकी सर्टिफिकेट को फोर्जरी करके लेके आए. He did not have a PhD certificate which was valid in those days, and the certificate which he has obtained from the corporation, from the university, is bogus one. So the court can give a finding with regard to character under section 52, making a departure. Please note that here. Okay, that is either the example. Now come to 53. In criminal cases, to understood this 52, समझ में आया आपको? In civil cases, the fact that character of any person concerned is such as to render probable or improbable. I mean, the civil cases, the court is deciding not on the basis of a strict evidence. It's on the basis of preponderance of possibilities. It is probable it has happened. It is probable not happened. Because your leading evidence of may presume, shall presume, unconclusive evidence under section 4. So the court may draw inferences under 114 कि ऐसा हुआ है, ऐसा नहीं हुआ है. So the plaintiff was asked to produce certain document, letter was given to him. He refused to bring. The court will say it is probable he is not getting those documents because they will go against him. See, this is called preponderance of possibilities, which is normally not decided in criminal cases unless the criminal case is of a civil nature, like a 138 cases. So, यहाँ पे probable, improbable conduct means the court will normally not impute dishonesty in a person unless the dishonesty itself is a relevant fact. So I gave you an example, number one, where the college management के अंदर one of the parties, plaintiff or defendant has forged signatures for claiming right title interest. The court has, that is, you come to know the forgery aspect when the trial takes place. The court may ask him to write a document for comparing the document. The court may draw that his character is useless. He cannot be appointed. Then in the case of a custody, husband and wife, custody should be given to the child, to the mother or a father. The court will examine the child in the court, though they are civil nature matters, matrimonial cases. अगर लड़का बोलेगा कि I do not want to go with my papa, every day he is talking to various females. Every day he is talking to various females. And the wife will bring on record he is having some kind of relationship with other women. So his character is not clean, custody cannot be given to him. So the court can pass observation in that regard. That is another example. See, these are the example. And in libel cases where the suit is, I'm not talking of the complaint, criminal complaint under 499, 500, 502. That is, it is a civil complaint under the law of tort, under the section 73 of the Indian Contract Act, where you claim proximate damages for harming your reputation, or in a breach of promises of marriage, you may take up the plea that I did not marry the girl or the boy because he is a person of ill repute. She associated with several paramours. I have taken photographs, CCTV camera pakdiyu mein. Isn't it? The boy has been sleeping with several women. Where's the question of marrying? So breach of promise. So his conduct is not good. So the court can draw inferences under section 52 with regard to the character. When it comes to the court knowledge, character is bad. Otherwise, civil cases are decided on the basis of preponderance of possibilities. And in a suit like breach of promise, court will see agreement hua hai, payment nahi diya time pe, suit is decreed, or the suit is barred by limitation, suit is dismissed. ऐसे चीजों में कैरेक्टर के जाने में सवाल ही नहीं होता. In a suit for dispossession, whether you're illegally dispossessed or lawfully dispossessed, the court is not too much going to the character of any person unless the character becomes relevant in the matter. You take up the plea that he is a habitual trespasser. He has trespassed also in the premises of my neighbor. Proceedings have been filed and his conduct is totally reprehensible. Then the court may allow you to lead character evidence, depends on facts of in each case. Anybody want to ask me question on 52? Please tell me before I shift to 53. Okay. This is the meaning of 52. Now 53 पे आ जाइए. In criminal cases, previous good character is relevant. तो सिविल केसेस में कैरेक्टर का सवाल ही नहीं होता unless it is brought as an issue. The court frames an issue and lead evidence. तो criminal cases में previous good character, oh, he is a man of sterling qualities. He is a good man. He has been trapped in the criminal case. The university has given him meritorious and his employers have given him certificate. And he is a social worker. Government of India has given him exemplary award. While deciding a criminal case, the court would be leaning towards the accused person. Let us see. In criminal cases, in criminal proceeding, the fact that a person accused is of a good character is relevant. So, prosecution will try to prove beyond reasonable doubt the offense is committed. He has to prove it, the public prosecutor. And if he is unable to prove the beyond reasonable doubt, then it is difficult for the prosecution to succeed merely because accused has not led evidence or accused has led evidence that he is a person of good character. So they are alleging me of a conduct which is that I have trespassed or committed riots, committed forgery, is totally false, fabricated charge. In fact, I have been given a good certificate by my administration, university, college, or the department where I am working for. So good certificate can be brought on record in the cross-examination of the complainant and the police officer. When you bring it, when they step into the box, while the police officer explaining the first information report to the court, that I have recorded this first information report against the accused person, complainant I the mere pass. These are the allegation according to me, the correct the charges bear. So a cross examination, when you put up you are an accused person as a defense counsel. Do you know that? Have you made proper inquiries about the accused person? Because as per the Dalita Kumari judgment under section 41 CRPC and under 154, 157, a police officer has to make inquiries. Inquiry nahi karega to fayda. Preliminary inquiry must be conducted. Did you make inquiry? With whom did you make inquiry? Police officer, if unable to say, have you made inquiry with the University of Bombay where the accused has studied? No. I bring to your attention the certificate which the university has honored him as a good person. Or I also bring to your attention the gallantry award which the government of India has awarded him. Have you made inquiries? So the court can take on record to prove that it is relevant. You should make a list of documents in the open court. My lord, I seek the indulgence of the court to rely upon this gallantry award, this certificate to prove that I'm a person of good character. Please note that a certificate you need not disclose it at the time, because in the cross examination these are 145 ke andar you are impeaching. Hmm? Or if the accused person has given you notice or before the trial court, before the trial court, before the trial court, at the time of giving admissibility, relevancy of document, a list is exchanged that can be given. Or in the cross examination, you put it up to the police officer. I put it to you that you are not made thorough inquiries about the conduct, reputation of the accused person. And I put it to you that the government of India has rewarded him with a gallantry award and a certificate of nobility. Look here, what do you want to say about it? So insist the court, this may be court bolegi how relevant. My lord, to prove that this is relevant under section 52 of the Evidence Act, 53 of the Evidence Act, to prove my character. Okay. ये कीजिए आप, this is permissible. Besides, it may be a rape case, it may be a forgery case. Generally, you are a person of good. It doesn't mean that a good person with the award doesn't commit offenses, but that's a plus point. समझे ना आप? Yes. Now 53A check कर लीजिए आप. Evidence of a character, evidence of character or previous sexual experience not relevant in certain cases. So the woman has filed a complaint against the accused person of outraging her modesty. 376 के अंदर हो या 354 में होगा, 354A में होगा, 354C IPC, various offenses relating to women are given here. So during that proceedings, accused is not entitled to take up the plea that the woman is of loose character. She is a woman of easy virtue. You cannot take up this plea. You are required to maintain the sanctity of the women. You are not supposed to do that. It is not relevant in criminal cases. In prosecution for an offense under 354, outraging the modesty, 354A, favorism, 354 BC, these are all inserted recently after Nirbhai's death, various sexual offenses after the POSCO Act came into effect. Then for attempt to commit any such offense, attempt to commit will come under section 500 and IPC ke andar 511, isn't it? Attempt to commit any offense where the question of consent is an issue. Evidence of a character of a victim. You may take up the plea that it is not a rape, I have not committed. In fact, it was a consensual act. She has been my friend, I have been known to her. We had this intercourse with a permission. That you may take up. But during that evidence, while leading the evidence that she has given consent, you cannot attribute to her she is a woman of easy virtue. She slept with several boys and several women. You're not permitted. Because on account of the social standing position, the Constitution of India giving a fundamental right to women under Article 15, subclause 2 and 3, yes, sub social condition. You're not given, you have to see the amendment. Okay. attempt to commit the offense, where the question is consent is issue, evidence of the character of the victim, such person, previous sexual experience with any person shall not be relevant on the issue of the consent or the quality of the consent. So you may be entitled to lead evidence, the act which has taken place, sexual act, it is not a force, it is not a rape. In fact, I have been known to her, she has been known to me. We have been working together, and she herself expressed the desire we have lunch or dinner or whatever may be. Let us get close to each other. So the act was performed with her consent. So that much you are allowed to lead evidence, that to show your association, your telephone calls, her telephone calls, you can lead WhatsApp messages to prove before the court it was a consensual act. But you will not be permitted to attack on her character by leading evidence that she has been sleeping with several boys and her character is bad. No, you are not permitted to lead good evidence. Okay, that you note, please. 54 में आ जाइए. Previous bad character not relevant. देखो वहां पे good character वहां पे relevant था. यहाँ पे previous bad character is also not relevant except in reply. So either the prosecution or the defense cannot take up the plea that so and so witness had a previous bad character. Now let us see that, unless it is in reply. In criminal proceeding, the fact that the accused person has a bad character is irrelevant unless evidence has been given that he has a good character, in which case it becomes relevant. If the accused take up the plea that, oh, I am a man of virtue, I have been granted many awards by University, Government of India, I have not committed this offense. Even kuch bhi nahi kiya hu. So you are permitted to gather evidence against him to rebuttal evidence. क्या बोलते हैं? Rebuttal evidence. In fact, look here, while you were in college days, a girl had prosecuted you for rape, for an attempted rape. There's an NC complaint. What do you want to say? Your character was so bad in your school, college days. You are permitted to lead that evidence, provided you have substantial evidence. It is only when he takes up the plea that I am a person of good character. To demolish his good character by way of rebuttal evidence. It is called rebuttal, to disprove his case. Somebody is proving his case, you are disproving. So while proving and disproving, what the court is considering all matters before the court. It may not be in pleadings. It may not be by way of an issue, or it may not be by issue of a charge, but it will come up the moment the man takes up the plea that I am a man of virtue, I am a saint, I have not done any such act, I have been doing a lot of charity. बोलेगा मैं चैरिटी बहुत करता हूं, करता था, अभी भी करता हूं. Then you can bring evidence to show that you were arrested for breach of trust, falsification of account. As a trustee of a particular trust, you were sentenced to jail. There were complaints against you that you have been fabricating accounts. And a criminal case is going on against you under section 467, 468, 477 and 420. You bring all this material because while conducting a trial, I told you, you must collect all material. You must collect all material. You must act like a detective agent. Unless you are a detective agent, your client should provide you. You should act as a detective agent, and you cannot be a good cross-examiner. So a cross-examination में आपको ये point मिलेंगे. So this evidence in rebuttal you can lead. For disproving it, the court may stop you. Where are you leading this evidence? Court may say that, my lord, I am drawing your attention to the provisions of section 4. आ जाइए. Number 1, court को बोलेंगे, you are trying to disprove the case of the applicant. I am a good character. Disprove. A fact is said to be disproved. How you are disproving it? When after considering the matters before it. So a matter mean evidence with regard to his character is a matter before it. The court believes that does not exist or consider the non-existence so probable that a prudent man ought, under the circumstances of a particular case, to act upon the supposition it does not exist. So he will take up the plea that I am a saint, I have not done anything. So you will gather evidence he was acting as a trustee of a particular trust, or maybe some mandir, some church, and they have filed case against him. There is a receiver appointed. The court has attached his properties and bank account has been sealed and monies are deposited. His character is tainted. So court appointed a commissioner. Commissioner collected his evidence. So under the CRPC, under section 19, 91, 92, you can make for search warrant before the court. Surprisingly, you can go. The bank lockers में पैसा छुपा के रखा है इसने. Where does this ill-gotten money you got from? Have you paid taxes on it? This is the money you have withdrawn from the trust, from the temple church without accounting for it. So he has committed misappropriation. So you will be permitted to lead evidence in this regard, and there is no bar. That is evidence with regard to character to show that this man is untrustworthy, and the so-called tall claim of he being honest are required to be refuted. Okay, that is section 53A. 54 पे आ जाइए. 54, I think we are relevant. Previous bad character not relevant except in reply. In criminal proceeding, the fact that the accused person had a bad character is irrelevant. So the accused person cannot be trusted. He has been prosecuted earlier, because that evidence you can take it up when he asserts in evidence. But on your own, in your examination chief, you cannot straight away attack the accused person saying he's a bad character. So in criminal proceeding, the fact that the accused person is a bad character is irrelevant. You are required to prove the particular charge in hand. अभी charge तुम्हारे पास कोर्ट में issue frame किया charges by the court that you have committed the offense of cheating, which is an offense under section 420 of the Indian Penal Code. But now you are trying to prove that cheating इसलिए किया होगा कि earlier he was convicted for the offense of defamation or for the offense of robbery. Those cases are irrelevant unless he himself brought up in the court, I am a man of good character. So a bad character evidence, criminal court ने कोई defamation case के अंदर उनको convict किया था, 1 day की सजा दी थी, और मे भी उसको जेल टर्म दिया था, that is not relevant in the second prosecution. It becomes relevant provided that man raises the plea and takes up that I am a honest man, I am a good man, I am a saint, I am a paragon of virtue. जब वो लेगा तो ही वो यूज करेंगे आप. अब if he is silent, if he is invoking his Miranda rights, चुपचाप रहेगा. Article 20 sub clause 3 के अंदर, not saying anything, and that man you cannot force him to give evidence against his previous bad character. In departmental proceeding में ऐसा हो गया था, चोरी किया उसने, and he should be convicted here also. And the inquiry officer found him to be a man who committed breach of trust. So according to me, the honorable court should convict him. That is not. You should not be allowed to lead that evidence. Inquiry proceeding ke paper, you not be permitted to lead for proving bad character. You may be allowed to lead for different things, maybe for deposition. But this is how the Evidence Act is, permitting you certain thing, not permitting you many things. You have to carefully read it. It's like more that meet the eyes. It is not just a very shallow act. It's a very, very well conceived act here. So how beautifully it is drafted. See here, the previous bad character is not relevant, and previous good character is relevant. Interesting, huh? 53 के अंदर previous good character is relevant है. 54 के अंदर previous bad character is not relevant. Okay. Now see the illustration. Yeah, in a criminal proceeding, the fact that the accused person had a bad character is irrelevant. Unless the evidence has been given, unless this man is beating his own trumpet, I am a very great man. Now let us see the explanation one. This section does not apply to cases in which the bad character of a person itself is a fact in issue. Agar from the very inception, bad character is brought on record, the court has framed charges. Then it is not relevant. In cases, bad character of any person itself is in bad character. Number two, a previous conviction is relevant as good evidence of bad character. So you may say that his man is saying he is very innocent and not committed any crime, and he is a person of good virtue, and he is having many certificates from the government of India, his institution, parents and friends. That is doubtful. I put it to you that your cross-examination, I put it to you that you were previously convicted by the magistrates court in Andheri in the year 1950 when a defamation suit or complaint was filed against you. What do you want to say about it? You can ask this. आप पहले पूछो, was there any defamation proceeding against you? वो बोलेगा नहीं, याद नहीं आ रहा है. You recall it, remember it. Was Mr. So and so your friend? Do you know that he had filed a case against you? Just remind him. वो अगर deny करेगा, look here, case number so and so was filed. You have a certified copy. अगर still वो pretend करेगा, I am drawing your attention to the certified copy of the judgment of the magistrate's court where you are convicted. What do you want to say about it? A certified copy of a court is a public document under section 74 of the Evidence Act. Unadmissible under section कल पढ़े हमने 36 के अंदर. Relevancy of entry in a public document or relevancy of a statement of fact irrelevant. Section 74 के अंदर also it is admissible, isn't it? So nobody can then under 40 earlier judgment, section 40, 41, 42, 43 tells you under what circumstances previous judgments are binding. That can be looked into. So here the previous character itself is relevant and it becomes admissible. Okay, that is how you can frame your question. You must be, if you are a good, when you want to be a good cross-examination, you should know the entire Evidence Act, CPC, CRPC well, and with your facts of the case. पहले facts पढ़िए, facts को paragraph बनाइए आप. These are the admitted facts, non-admitted facts. These are the facts which are silent facts. Admitted fact need not be proved, section 58 of the Evidence Act. Disputed fact, documents which are come on record under the document belonging to the defendant which you want to cross-examination, mark them under section 145. Document which have not been relied upon by him in his plain or written statement, put them in the category of order 7 rule 14 under order 8 rule 18A. How they cannot be relied? Order 13 के अंदर mark करके रखो. Interrogatories which are admitted, not admitted. Order 11 के अंदर आएंगे. Documents which needs to be rejected under order 13 rule 1 and 2. That you should know because Evidence Act, CPC, CRPC contain the rules of not only the Evidence Act. ये सब रखेंगे आप, then you will be able to ask these questions very well. Okay. Now come to section 55. Then I will take down the question answer. Character as affecting damages. This is especially civil cases under the law of tort. Law of tort and Indian Contract Act में भी कर सकते हैं आप ये. In civil cases, the fact that the character of any person is such as to affect the amount of damages which he ought to have received is relevant. So defamation charges, liable, you will be filing it both under the provisions of section 499, 500, 501, 502, 503, 5 करेंगे आप. That is where the magistrate takes care of the putting him in jail. Claiming damages on account of the malicious act. Malicious prosecution, a false complaint was filed against you. You went to the High Court, got it quash, or you have been honorably acquitted. You move the court. He has tarnished my reputation by getting me arrested, by lodging a false FIR. The entire society has come to know, getting it published in newspaper. So I'm seeking damages. So in this suit, you can rely upon the previous judgment, previous fact, a good character, bad character. Even in civil cases, the character is an issue. You will be permitted to invoke the evidence with regard to character that the respondent defendant is a person of malicious nature. He is a vindictive nature. Now, recently in the Supreme Court yesterday, a judgment came from Bangalore. Azim Premji ke khilaf, his own employee filed 70 criminal cases. कितने? कोई Ramaswamy करके name I do not know his name. It's come in the newspaper. See, it is all over. And the Supreme Court praised the gentleman, Azim Premji, for forgiving his employee who harassed him by filing 70 false criminal cases. He had to go to the Bangalore High Court, Karnataka High Court, and move Supreme Court several times for caution. और उसने Supreme Court suggestion दिया yesterday, end this matter, settle the matter. And the Supreme Court praised the gentleman. He has been magnanimous. Of course, he had filed several cases for damages also in Bangalore court, but all complaints were withdrawn. So if he wanted to pursue his civil cases for damages, he would succeed. But yesterday only 70 cases were filed in criminal cases in Bangalore. कल जजमेंट आया, देखो पढ़ो, उसके अंदर ये लॉ, लाइव लॉ के ऊपर है, यूट्यूब के अंदर भी है. That is one example. That is not used because otherwise the plaintiff, the complainant can use this to prove that the defendant or the complainant is a person of a malicious nature. His tendency is to only initiate proceeding. There's a vexatious proceedings act. With the help of the Advocate General, you can get the proceeding quash. You all should know that here. Criminal cases, even civil cases, at times you can move the court under Article 226 for getting quash, which is rarely done. But under the provision of CPC, Order 6, Rule 7, Order 7, Rule 11 is the provision for setting aside or quashing the complaint on the ground that there is no cause of action. Okay. Explanation. In section 52, 53, 54, 55, the word character includes both reputation and disposition. But except as provided in 54, evidence may be given only of general reputation and general disposition and not of a particular act which reputation or disposition were shown. So there is no mandatory requirement that you must lead a cogent evidence. General reputation, he is a man of good character, general certificates. His organization, where he has been working, he has been hailed. Government has given. The neighbors, you examine couple of neighbors. Yes, the defendant is a very helpful person. He always come to a help rescue. The local police administration also says, yes. Bad character evidence ke liye, if a man is pleading, I'm a good character, a previous conviction recorded against him can be a good certificate. Okay, this will conclude on the relevancy of evidence, the kind of evidence you are permitted to lead, whether this evidence is collected by you legally or illegally. It is relevant, is permissible. Huh? Yeah, anybody want to ask me any question? Ask me. Then if the time permits, we can start with chapter 2 also, part 2. Yeah, anybody has any question? I can begin the judicial fact 57, 56, 57, 58 तक ले लूंगा मैं. हाँ? I will stop today after 58. Then 59 next lecture. I will be meeting on Tuesday, not Monday. Monday I have some big problem. Tuesday I'll meet you. Abhi today I will take 56, 57, 58 तक. Anybody want to ask any question on character evidence? Please ask. थोड़ा जब तक मैं पानी पी लूंगा.
Sir,
Yes.
good evening, sir.
Good evening.
Sir, under 53A, sir, I just want to make a clarification that previous sexual experience of the accused person is also saved along with the previous experience of the victim woman.
Yes.
Okay,
Yes.
sir, and
Ask
just
for, yeah.
one more thing. So why would a person
Put
lead
character assessment.
evidence?
Hmm. Hmm.
Why would a person will lead evidence so as to affirm that he is a man of good character? Because ultimately, the prosecution is going to demolish his character by leading rebuttal evidence. And what purpose does it serve to the person who will affirm that he is a man of good character? Ultimately, because offense has been committed by him, he is going to be punished anyway.
No, if a person, the court will show leniency in the matter of awarding punishment. If it is 10 years, the court may say, okay, 2 years, 3 years. That may be helpful in various factors. In considering the fact that having regard to his age, his contribution to society, a good character, sentence can be reduced. Ultimately, it doesn't mean that the charge will be wiped out. Huh? The charge will not be wiped out. If you are able, if the prosecution is able to prove the charge beyond reasonable doubt. This is for other purposes. It is not just for convicting or releasing him permanently or acquitting him. This can also be the court may consider for the purposes of what should be the amount of punishment he should undergo. Or only fine is sufficient. हाँ? और प्रोबेशन ऑफ गुड कॉन्डक्ट के ऊपर फाइन लेते ना उसके अंदर आपने पढ़े हैं 101, 102, 103, 105, 107, 108 breach of peace provisions. That is the object behind. Okay, not because to nullify the
Yes,
entire. Yeah. Yeah. Any other question?
understood.
56 पे आ जाएंगे अभी part 2. What you learned so far is a part 1 which included the fact in issue and relevancy of facts. Now it is proof. Court wants proof. How the evidence which is sought to be led is to be proved. Isn't it? The very, very important chapter. Part 1 में relevancy of fact, whether it should be admitted or not, should be taken or not, ये relevant है, irrelevant है. It is not a complete proof. The court may take a document, it may exhibit it. Mere admission, mere exhibition of a document is not proof. The contents are required to be proved. The expert has given evidence through his report, court may report exhibit ho gaya. But the evidence, the report must be proved by the expert. The will of your grandfather is brought on record by consent proved. But the contents must be proved. The persons who have signed it must come and depose. I have signed it in the presence of the testator. And the testator in my presence signed it, the other witness signed it. Then it becomes. Otherwise, merely taking the evidence on record, relevancy is admissibility, different thing, and proof of a document is document evidence. Now, please note that. So, not to get excited, any lawyer, अरे मेरा document admit हो गया. No, you must prove it. How it is proved? that will show from this section 56 onwards. Okay, let us see. Now, what documents, how they are proved before the court of law, because section 4 tells you for proved, disproved, and not proved, how you are supposed to lead evidence. May presume, shall presume, unconclusive proof. When the court draws inferences, इसके लिए ये सब चीजें काम आएगी. Number 1, check करें. Fact judicially noticeable need not be proved. Interesting. See, the Evidence Act is trying to lessen the burden of the prosecution and defense. No fact which the court will take judicial notice need be proved. Now, judicial notice the court will take what? For example, what are the example? Can anyone? The sun will set from the east. उसके लिए क्या proof चाहिए? You need to examine. Huh? ये जमीन गोल है. It is going across the sun. Isn't it? The sun is moving across the earth. These are all judicially noticeable facts, scientifically proved fact. They need not be proved. India became independent in the year 1947. It's a judicially noticed fact. Everybody knows. The World War took place in the year 1942 to 47. It's a fact well known and documented in history. उसके लिए history पे क्या? The French Revolution took place. Isn't it? The Aryan Empire, Mughal Empire, the Mongolian Empire, Chinese Empire were in existence in those periods. So these are all judicially noticeable facts. They are not required to be proved. They are well documented. The Newton's theory is well known to everybody. Scientific experiments. So the court will take judicial notice of the fact. They need not be proved. The court should not be wasting its time. Okay. उसके लिए सब of course, you have a easementary right which is disputed, you have to prove it. Court will not prove that here your grandfather or forefather had a legal right. A court will take a judicial notice of the fact Himalaya mountain is situate from Tibet se lekar India mein aata hai. Isn't it? That will take judicial. Ganges river Ganga is flowing from the Himalaya, it comes to Allahabad and various parts of India. The court will take judicial notice. Isn't it? These are the facts. Birth of a child will take place when there's an intimacy between husband and wife who live together. For so and so. Court will take judicial notice. So these are all several facts. You can just go down and see. There is no need to give illustration more than that. Then next. Facts of which court must take judicial notice. So the earlier one, they need not be proved because they automatically happen. Storm comes and goes in the river, particular period. High tide and low tide comes in particular time in ocean. Court ko malum hai. These are all need not be proved. Now, some of the facts the court will take notice. The court shall take judicial notice of the following fact. There is a mandate issued by the Evidence Act that the courts are enjoined with a duty not to waste the time directing parties to lead evidence on certain facts which are judicially noticeable. Number 1, all laws in force in the territory of India. Constitution of India has been adopted and written. It is a fountain of all laws. There is entry 7. There is a central state list, central list, concurrent list. Court will take judicial notice. The court will take notice a particular law has been repealed. The court will take notice of the fact that here various states have power to legislate certain laws and the laws have been enacted. So, Sati law has been passed by the parliament, abolishing Sati practices. Parliament has passed Dowry Prohibition Act. The court will take judicial notice. So all legislations, both central and state government which has been passed, court will take notice. Court will not tell you that here ऐसा कोई law नहीं है, you bring it here, prove it here. There is no need to prove. When law is passed, the parliament has competent to pass the legislature has passed the law unless it is set aside by the Supreme Court. Unless the parliament has repealed it. Repealing powers are given to the parliament. Quashing powers are given to the constitutional courts, Supreme Court and High Court. Isn't it? Yes. Number 2, all public acts pass are hereafter to be passed by the Parliament of the UK and the local and personal act directed by the Parliament of UK to be judicially noticed. So when the Evidence Act was written, United Kingdom ke laws were in force. 1935 Government of India Act was in force. The East India Company was in force. So the laws which were enacted by the British Parliament, now you can substitute it to Indian Parliament. Isn't it? The law CPC, CRPC is the law. Both the central government and the state government passes is under the concurrent list and is in force in India. You can take cognizance. Isn't it? A substantive law, Transfer of Property Act, has been amended by certain states in certain manner. In a state of Punjab, it is not in existence. The court will take cognizance. Certain territories, certain urban, certain territories such as Assam, Nagaland के अंदर, the laws made by the Indian Parliament, a legislature, are not in force as they are governed by tribal rules. Court will take cognizance and the court will take judicial notice. That is section 4 and 5 of the CPC, CRPC check करेंगे application of the Act 1 and 2 and in the saving clauses. Number 3. Articles of War of Indian Army and Navy and Air Force. So the court must take judicial notice in cases where the India is engaged in a war with its enemies. The Articles of War and Indian Army Naval Force were pressed into service against Pakistan, against China, against the enemies who are India is having hostility. The court will take judicial notice. The course of proceedings of Parliament of UK, of the Constituent Assembly of India, of the Parliament and of the legislature established under the law for the time being in force in provinces or state. So the court will take judicial notice of the fact that here, at the time India was partitioned, there was an Independence Act of India, isn't it? There was an Independence Act. The legislatures of various states were established. The Rajas and Maharajas were in. Their accession took place. So, under the provisions of section 113, it is a conclusive proof to show the proof of cessation of territory took place, isn't it? So the court will take judicial notice of the facts relating to 113 of the Evidence Act and section 57. These are judicial notice fact, and these are also conclusive. The Rajas and Maharajas who were holding territories prior to partition, the government of India, and by notification in the official gazette, official gazette, accession took place. So the court will take judicial notice of that. Number 5, the accession of the sign manual of the sovereign of the time, being the UK and British Britain and Ireland. So at the relevant time, the court will take into consideration and judicial notice on account of East India Company prior to the partition of India, prior to the Independence Act, and after the Government of India Act 1935. Accession of the sign manual sovereign of the time, UK and Britain and Ireland, were in force and prevailing in India. So the court will take judicial notice. Number 6, all seals of the court will take again judicial notice and must take judicial notice. Number 6, that the seals of which the English court take judicial notice, seals of all the courts in India and of all the courts established by the territory, central government, state government, crown, representative of the seals of the state, admiralty, maritime, jurisdiction and notaries, public seals person, and the Constitution of India, Parliament of UK. So the courts are also enjoined with a duty to take a judicial notice that all the seals of the Supreme Court, High Court judges, notaries, and various public officers are valid, are to be duly taken, to be taken cognizance of, and there is no need to call for those persons to give evidence. Okay. The court will dispense with the requirement of coming and giving evidence in this regard. Okay. Then number 7. The accession to the office, name, title, function, signatures of the person filling for the time being public office of any state, in fact, and their appointment to office is notified in the official gazette. So every appointment of a Supreme Court judge, High Court judge, or every public servant, in fact, is notified in the official gazette. So the court will take a judicial notice. The particular post has been duly done, unless fraud takes place, unless seals are bogus, fraud will vitiate everything. Otherwise, the court will not waste its time in taking judicial notice. 8 number देख लीजिए. The existing title, national flag of every state, foreign country, and a government of India. So the court will take into consideration and take cognizance of and judicial notice of flag of each country. The court will not come and tell the lead evidence that which particular country has which flag and who prepared it, how, when it was invested. Isn't it? Number 9, the division of time, geographical division of the world, public feasts, fast, holidays notified in official gazette. So the courts will take judicial notice of the holidays which are mentioned in the Negotiable Instrument Act. Under the Negotiable Instrument Act, section 80, I think I'm not mistaken, tells you the holidays which are to be given. Chuttiyan. And division of the world over, the map, world map, the court will take cognizance. Germany has split into 2. Africa is split into 2. India has split into 3. These are all geographical divisions of the world. Court will take judicial notice because these are all officially gazetted. India has as many as more than 27, 28 states. These are all gazetted. There's a State Reorganization Act. The court will take judicial notice after the Government of India Act. After the Independence Act of 1947, India enacted the State Reorganization Act to give autonomy to each of these states. Isn't it? India, that is Bharat, which is Union of India, Union and of these states, the court will take judicial notice. 10. The territories under the dominion of the government of India. Now, what are the union territories? Delhi is a union territory, isn't it? Formerly, Goa was a union territory, now a state. Now, there are many union territories in India, which are Constitution of India makes a special provision, isn't it? They are directly under the control of the central government. There's a lieutenant governor appointed. The court will take judicial notice. There are as many as, I think, 13 union territories in India. The commencement, continuance, and termination of the hostilities between the government of India, any other state body or person. So the court will take judicial notice. At present, we are on war path with Pakistan, with China, with regard to our territories. So they have an evil eye towards our Indian territory in Kashmir or many other Nagaland and many other properties. So constantly there's a vigil. There are armed forces which have been set up. So the court will take judicial notice. There is unrest with regard to their own neighbors. Then item number 12. The names of the members and the officers of the court and their deputies and subordinate officers, assistant, and of the officers acting in execution of the process, and of the advocate, attorneys, proctors, vakils, pleaders, and other person authorized by law to appear and act before it. So the court will judicial notice of the fact that the judiciary, India ke andar, there is a higher judiciary, there are high court, there are district court, there are subordinate courts, there are judicial magistrates, there are subordinate magistrates, court of sessions, there are advocates who are practicing officers of the court. So the court will take judicial notice of all these officers of the court in the matter. Then rule of the road or the rule of the sea. The court will take into consideration the rule of the road and rule of the sea. India has in the cities, all big cities and towns in India have railway link from Mumbai to Delhi, Delhi to Banaras, Kanyakumari, and sealing India to USA, Dubai, Iran, all these places. India has got sea routes where we do commercial business, maritime business. So the court will take judicial notice of this fact, which need not be proved. In all these cases and on the matters of public history, literature, science, and art, the court may resort to the aid to appropriate books or documents for reference. So the court is at liberty to peruse the books of history of eminent authors to ascertain, to come to a judicial notice. And they see the biographies of the eminent the writers, what they had to say about the facts where the court can take judicial notice. The court can take judicial notice. There are several international conventions, Uruguay Convention, Morocco Convention, New York Convention, there's a Paris Convention, there is various convention. India is a signatory to various international convention. So all these convention, all these bodies, dignitaries, which are all gazetted, which are also written many books, court will take a judicial notice. If the court is called upon by any person to take judicial notice of any fact, it may refuse to do so unless and until such person produces any such book, document, as it may consider necessary to enable it to do so. So you cannot compel the court, must take it. You must, as a young lawyer, as a junior, senior lawyer, you must be ready with your books, ready reference. The court may take a judicial notice of the fact that this precedent was followed by the American court. The court may kindly take a judicial notice of the fact that here in the Second World War this happened, and the NATO came into existence, isn't it? Abhi war chal rahi hai abhi, huh? USSR ki and neighboring country ki. The NATO came into existence principally to keep the USSR under control. The aims and object were that to stop the aggression. Why the international treaties came into picture? After the Second World War, so many treaties were established. The court asks a question, keep them ready. They're all on the net material. The international court is established and set up. The international court has given several rulings. And these are the rulings, and keep them ready. This is the view the International Court of Justice in Hague has passed. When territorial dispute with regard to foreign country comes into picture, when there is a there's a universal declaration of human rights, which are in consonant with some of our fundamental rights, where the India is a signatory and bound and liable to respect. And such treaties are shown to the Supreme Court judges by lawyers arguing the cases. So you have to keep them ready. As a lawyer, you just cannot make a bald statement to the court, this has happened. So keep all these treaties and books ready. Judgments are all published everywhere. Keep them ready. So when we argue cases, we keep ready. Just let me come here. I'm in lecture. I'll call you later. So when you argue cases before the court of law, you cannot tell the judge, learned judge, the Supreme Court has declared in so many cases like this. No, you get a Xerox copy. This is the view taken by the Supreme Court in this matter. This is the view of the American court in so and so matter. This is the view of the British court in so and so matter. The Xerox copy, the court will take judicial cognizance. Yes, the court will take cognizance of the copy which you are producing. Okay, that you keep it ready. Now come to 58.
So one question, sir. May I please, sir?
Yeah, please.
Sir, these are the 57 gives out the facts with judicial notice. What are the occasions when this judicial notice has to be taken, sir?
There are several matters which are coming up before the Supreme Court and High Court with regard to taking judicial notice. अब वो केरला के अंदर शिप हो गया ना, 2 fishermen were killed. What is the noctur miles? What is the distance? Who are the citizen? Who are not? The human right declaration. ये सब पढ़े. When you read the judgment, you will come to know. All these international law disputes, they come into play when the court can take judicial notice of certain existing judgments, existing policies. Padhiya, some Supreme Court judgment on that point. I'm giving you the famous case of where in Kerala, the fishermen who were fishing, they were killed, bichare, because the Italian ship people, the matter got compromised. The Supreme Court was dealing with various matters. What are the international right, human right? What should be the contemplate? Within whose mile, in which water is Arabian Sea, Indian Sea, International Sea? When the court can draw presumption? When dealing with matters under the international arbitration, what is Uruguay? What is the UNCITRAL laws? United Nations Commission of International Trade Laws. What was discussed by why these treaties came into picture while resolving certain dispute, while dealing with international dispute, even for adoption of a child, Indian parents, Indian couple go abroad and take divorce, and they take into consideration what is the law of India, how to take judicial notice. What does the Supreme Court of India said it? So when you read this judgment, then only come to know there are lots of judgment on that point. See, net pe jaake mariye milega aapko. Some judgment I can give you also. Lots of judgments.
Thank you, sir.
Okay. Anybody has any question? before I shift to section 58, which is the last section of today's discussion, which is normally used in all cases and where in civil criminal cases. 58. Facts admitted need not be proved. No fact need be proved in any proceedings, maybe civil or criminal proceeding, which the parties say to or their agents agree to admit at the hearing, on which before hearing they agree to admit by writing, under their writing, or which by the true pleading or false at the time they are deemed to have admitted by the pleadings, provided that the court may, in a discretion, require the fact admitted to be proved otherwise than by such admission. Now take for example, now this section come into play in the court proceeding when your plaint is ready, written statement is ready, the court has framed issues. Okay. Court has framed issues, both the parties are directed to file affidavit of evidence. Both the parties are directed to file the affidavit of documents under order 11 rule 13 में you file करते हैं आप. Another 5 minutes. When the list of documents are filed, for example, by the plaintiff, so you file the examination chief के साथ में list of documents on which the plaintiff rely upon. So those are the documents which a plaintiff is normally relying upon in order 7 rule 14. Barabari? Then under order 7 rule 14, some of the documents you are not disclosing. Then under the provisions of CPC, you learn that is order 11 rule 13, privileged documents which need not be disclosed. Affidavit be filed kiya aapne. Why you are not disclosing, in whose possession they are there, you have to give reasons. And the court will not directly admit your document, will ask the other side to give the say, whether you are admitting, not admitting. So that order will be passed by the court under section 135 of the Evidence Act. Please check 135. This section I have been taking you through with 135, 136. Judge to decide the admissibility of evidence. So the document which you are tendered, they don't become admittedly automatically. Then under the provisions of order 13 के अंदर भी first order 12 में आ जाइए. What are the admissions? Order 12 check करो आप. First 10 में आ जाइए. Order 10 के अंदर the judge will ask you, what are you admitting or not admitting? Order 9, order 10. Examination of parties by the court. At the hearing, at the first hearing of the suit, court shall ascertain from each party or its pleader whether he admits or denies. Admit or denies. You have to give what document, what evidence you are admitting. Number one. Number two, in discovery inspection में order 11 rule 13 में affidavit document you are filing. All list of documents you are giving, which are given in form number 5 appendix 6. Mean the document which I admit, which I do not admit, which I want to give, which I do not want to give. वो पढ़ चुका मैं आपको. Then order 12 में आ जाइए आप. Order 12 कहता है admissions. Parties may give admission. What are you admitting? What are you not admitting? Notice admit कर लेंगे तो court में order 6, order 12 rule 6 में the court can pass a decree also. Then order 13 में आ जाइए. Certain documents which are produced before the court can be impounded. Mean the court can send them for registration. They are not sufficiently stamped. Section 49 में your lease document, your mortgage document, you are relying upon a gift deed which requires registration. Mortgage deed requires registration. You are producing copy. Court will impound them. the admission relevant document 13 के अंदर original document number 3 endorsement of admitted document rule 4 में. So normally what is admitted document? So considering your affidavits, considering your correspondence and your reply. Number 1, lawyers have exchanged correspondence during the suit. They are all admitted correspondence. Reply, rejoinder. Before the check bouncing or filing a suit under Order 37, Rule 1 and 2, summary suit. Check दिए, check bounce होगी, आपने letter दिया, reply, rejoinder. They're all admitted document. Admitted document, the court will say they are exhibited. They don't require to be proved. Something you are admitting, आप बोलेंगे, you are filing a suit for possession based on an unregistered document. Defendant बोलेगा, I object to this document. Because under section 49 of the Registration Act, the document required registration. Under section 17, registration, a compulsory registrable. The document cannot be admitted, cannot be looked into unless you show that this document I am showing for the purpose of specific performance or for using as a collateral transaction to prove fraud. 49 में proviso पढ़ेंगे आपको मालूम पड़ेगा. So I won't be taking you through. Many times I have shown you this. So bear in mind. Admitted documents where you are given a list under section 136, court will say plaintiff has admitted the document. Yeah, admit. Mere admission, you may say admit the document, contents are not admitted. That means you have to examine the deponent. किसने लिखा, कितने sign किया. Prima facie, the making of a will is admitted, but the deposition, attestation is disputed. So it's a tricky provision. Section 58 should be read along with section 136 of the Evidence Act and the provisions of CPC, Order 10, Order 11, Order 12, Order 13 and CRPC में section 273 से लेकर 299 तक. So we say that inquiry and trial before the court. तो वहां पे भी CRPC के अंदर code of CRPC मेरे पास नहीं है इधर. There is a relevant section which tells you admissibility, denial and acceptance to be given. 297 कुछ चेक करो उसके अंदर. CRPC के अंदर just check करो. That is similar to the provisions of Order 12 and the provisions of Order 10. So 58 tells you admitted fact need not be proved. So pleading check करो आप, pleading check करे, pleadings, that is plain written statement. My lord, in the written statement, defendant has not disputed the liability. Yes, it is true that I owed him money. Promissory note has been executed. But the same was taken fraudulently by inducing me to sign it. Okay. Inducing me to, you're leading evidence of fraud. The court will say document is admitted on record. Whether the signature was obtained by use of fraud, that is a matter of evidence. So you can lead evidence of fraud under section 92, proviso 1A and B of the Evidence Act. So under 136, the court will decide a document admit हुआ नहीं हुआ है. The judge will give his finding. Whether the party proposes to give evidence of any, judge may ask a party proposing to give the evidence, in what manner he alleged to be proved. Whether you are proving it by secondary evidence, by primary evidence, whether you are proving it by circumstantial evidence, whether you are proving it by indirect evidence. That a lawyer, as a young lawyer, you have to make this statement. Young lawyer, a seasoned, unseasoned lawyer, that will be required to be made. Somebody is calling me. I won't take up the phone. Okay, please note that. Only admitted facts where the written statement may or in the affidavit at the time when the court passing order under 136, when examination chief is filed, list of documents are given. I admit, I do not admit, the court will give. Those documents which the plaintiff are not admitting, court will hear both the advocates. He is disputing the document. What do you want to say? You may say that, my lord, this document is relevant. Number one, how is relevant? You are producing a Xerox copy of a document. You know? Xerox copy of a document. Xerox copy not admissible. You may argue that. Well, this is a Xerox copy taken from the original document. My original document is misplaced. Lost, I had lodged a FIR copy. Under section 63 and 65, I may be permitted to lead secondary evidence. So please note that. By virtue of secondary evidence, I had given notice to the other side under 66 to get the original. Or I had lodged a FIR to the police station. I will examine the police station if need be. That is how you prove the document under section 136. Otherwise, if the other side is admitting, that will go as an admitted document under section 58. Correspondence of lawyers are normally admitted. In a matrimonial case, for example, husband and wife are quarreling each other. Wife is saying, he is abusing me. His conduct is guilty of cruelty. I wrote a letter. His advocate replied, rejoinder. So all these correspondence taken on record, contents are to be proved. Please note that. Documents may be taken on record as admitted document, but contents are not proved. Unless you step into the box, unless you cross-examine, impeach the credibility, whether the statement are correct or not, they will be admitted. Okay, otherwise, section 58 only prima facie takes admissibility, just admitting the document, but the proof is not come. Relevancy is come, it is relevant to the issue. The suit is filed for cruelty, and there's a correspondent where the wife has alleged the husband has demanded money, demanded car from his family people, and he is abusing her all the time. It is a relevant fact. Whether it is true or not, वो देखा जाएगा. But correspondence है, reply rejoinder है, take it on record. Police has filed first information report, examine witnesses. Under 161, the police has examined Mr. A, B, C, D. All these witnesses. One witness is dead and gone. A list of witnesses given. Merely the statement of a person given under 160 is not evident. Under 162 is that clearly say no evidence. But if they are produced before the court of law. Panchanama is produced. Panchas, panchas are produced. Panchanama cannot be admitted ultimately. The police officer must examine the witnesses who were present. Recovery of the proceeding under section 100 of the CRPC में check करेंगे आप, वो provision है. सब clause 3 के अंदर. Two respectable witnesses of the locality. The police officer, the accused made a statement of recovery under 27 of the Evidence Act. Pursuant to recovery, छुरी मिली, एक कपड़े मिले, blood stain report मिला. The police officer just cannot take it and go home. He has to keep it, take photograph, call witnesses, call experts. उनके सामने सीलिंग करेगा, उसके सामने उसको सील करके सिग्नेचर लेंगे. Those witnesses must report. हमारे आंखों के सामने ये हुआ. पुलिस ऑफिसर ने बुलाया था. The accused person made a statement and we know what he said. वो स्टेटमेंट में कहा कि उसने छुरी यहाँ छुपाई थी, उसने कपड़े यहाँ छुपाए थे. And pursuant to his statement, the police officer led. I also went along. I am staying in the close vicinity. So they were recovered. In our presence, the police officer sealed them. He called the photographer. Photographer took photographs. Fingerprint experts were called. Footprints experts were called. They did the job in our presence. ये बोलेंगे, then they admitted facts. That becomes proof of the fact. अगर वो सब नहीं करेंगे, this is not admitted. Okay, the correspondence in proceeding. If a correspondent lawyers are produced, say the correspondence of settlement is without prejudice, section 23 lag jayega. Admission cannot be admitted. We held the meeting without prejudice to my rights and contention. Of course, we agreed to pay the money instead of 1,75,000. To buy peace doesn't mean I am liable. That statement was made without prejudice, section 23. So the court will say the letter taken on record subject to proof. So normally the court takes the letter taken on record subject to identification. Certain witnesses are directed to produce document. Production documents, you cannot be cross-examined. You will write to the electricity authority, you're a landlord, that the tenant has not used the premises for more than 1 or 2 years. The house is lying locked and electricity meter chalti nahi. So as a landlord, as advocate, you will write to the electricity department. You are requested to produce the electric records of this particular meter. Only is a production witness. Yeah. उससे question, हाँ आपने record लेके आए. So that record you can contradict the tenant. Is it your meter? Why is it showing 0 meter? That means you are not resided. You are not used the premises. Premises has been damaged. So under the rent control legislation, if the tenant does not use the premises for more than 6 months, he is liable to be evicted if he doesn't give reason. That is how you prove it. Huh? Okay. आज के लिए topic बंद. Anybody want to ask me question करो. Monday I will not come. Tuesday will take lecture. Tuesday, Wednesday and Thursday I can take. Thursday I am not in Bombay. Tuesday, Wednesday. बता दीजिए. I think we should be able to cover your evidence act because I think यहाँ से पूरा act I have taken through more or less. And it will not take much time. Should be able to complete this by the end of this month. Anybody has any question now?
Sir?
Yes.
So I have a question related to perjury and hostile witness.
Yes.
Sir, first question is what is the line of distinction between perjury and a hostile witness? Because a witness may be telling the truth, but still he may be going against the party from which he is testifying. Second, sir, whether only prosecution witness can be held as a hostile witness or the witness is testifying from the side of defense accused person can be also be regarded as hostile witnesses.
Any witness, it should be your witness. Yeah, it may be prosecution witness or defense witness. Huh? If he's not supporting your case, 161 statement recorded by a police officer, that statement, the witness is not supporting you.
But sir,
He
when
can
defense,
bolo.
but sir, when defense produces any witness, he barely he will not be having any 161 statement. So you are
Not necessary. Under the provisions of the scheme of the CRPC 315, the accused has a right to examine his own witnesses. 315, 311 में the accused case statement, 315, 16 check करो आप. The accused has a right to examine himself and his witnesses. And on the session trial, foreign trial में procedure है 225, 20 सब देखिए आप. So the defense can also examine witnesses. If his own witnesses are not supporting him, he can declare them hostile under section 154 it is, if I am not mistaken. Okay. You can put normally examination chief ki jagah, you can put to him question and cross. Yeah. Yeah. or anybody any question? ये हो गया. And perjury के अंदर it is a one provision that section 340 will come into play. And somebody is waiting for me. I will take your question the next time because somebody wants me, somebody leaving abroad want to speak.
Yes. Yes.
Okay. We'll postpone it and Tuesday we'll meet up. Okay. I'm winding up and all questions, Ashutosh, please take down. Tuesday को मिलेंगे. Okay.
Sure, sir.
Thank you. Bye-bye.
Good night, sir.
Good night.